Okay, today we're going to talk about answering the question, why were special needs trusts invented? What is a special needs trust? What is a third party special needs trust? What is a first party special needs trust? And how do spouses create special needs trusts for each other? Okay, first of all, why were special needs trusts invented in the first place? What had happened was when you're getting government benefits, entitlement programs like disability, Social Security, Medicare, Medi-Cal, you're only allowed to have certain assets. If you have too many assets, you would not qualify for that program. So let's take a person that's a child, 8 years old, developmentally disabled, and on public assistance because of not enough assets. Okay, so they get the public benefits. And let's change the example to somebody who has Alzheimer's disease. They're incapacitated. They're in a care home, skilled nursing facility, and they are paying like about $6,000 a month in care costs, and Medi-Cal is paying for it. Well, if they own property or have other assets, like a house, when the person passes away, Medicare will take and file a chargeback against the property to recover their payments to that person. And it might be $800,000 of chargeback. So, and in an example where a child who's on public benefits, developmentally disabled, and they receive a large inheritance, and let's say they're on Medi-Cal or SSI, then when they receive a lot of assets, they're kicked out of the public benefit program until they spend down all of their assets, and then they have to reapply again after they've dissipated all their assets. So a special needs trust was invented for that reason, so that people would not lose the entitlement to their government benefits. So what is a special needs trust? A special needs trust is a certain type of trust. First of all, a trust has three parties: a settlor, or the person with the money or assets who creates the trust. Then there's a trustee who manages the assets and has the assets in their name as a trustee. And then there's a beneficiary. And in this example, the beneficiary is the developmentally disabled child. The trust is irrevocable. It's non-changeable. It's different than what you would use for an estate planning trust that is a revocable trust. These are irrevocable and not changeable. So these types of trusts are used when a person is receiving what they call means-tested public assistance. Means-tested public assistance is that if they have their own money, large amount of assets, cash, whatever, then they don't qualify. So the idea is to keep the money away from the possession and control of the person qualifying for the benefits, so that those assets can be used for special types of things that the individual needs. In order to have a special needs trust, the trustee must have what's called discretionary distribution rights, that the trustee can decide on buying things or paying for things for the ward, the incapacitated person example, but there's no requirement to pay a fixed amount, like $10,000 a month or something like that. It's all discretionary, and the beneficiary can have no access to the funds. They cannot have signatory authority on bank accounts or investment accounts. And the ward or the person receiving the benefits cannot appoint themselves as trustee on their own special needs trust. Now, there's a couple types of special needs trusts, one of which is referred to as a third-party created special needs trust. And what that is someone other than the beneficiary has assets. Let's say it's part of an estate plan from parents to a child. And so the creator of the special needs trust, the settlor, has the assets, not the beneficiary. They create this trust and put their funds into it. They're called the settlor. And the person putting the money in might also be the trustee, and that's fine, but they cannot be the beneficiary. And in a special needs trust, there are specific language in the document to protect the public benefits that the person is receiving. So if Social Security is paying the monthly rent, then there would be a prohibition against the trustee paying the monthly rent or giving the beneficiary more than $2,000. Because if the beneficiary has more than $2,000 in cash, then they wouldn't no longer qualify for the public benefits. And the third party created special needs trust is an asset protection trust, in that if the ward or the disabled person files bankruptcy, for example, the bankruptcy court has no control over accessing that money in the special needs trust. And if there's a large creditor problem, the creditors cannot come in and take the money. So it's protected from government intervention and taking the money also. Then there is another type of special needs trust referred to as a first party special needs trust. And this would be a situation where, hypothetically, let's say somebody's diminishing their capabilities quickly, and they know that pretty soon they're going to be incapacitated, let's say deteriorating with Alzheimer's example. So they put their own money in a special needs trust. They're the settlor of the trust. And let's say they have another person as trustee, and they've named themselves as beneficiary on their first party special needs trust. Well, this trust still works for maintaining the public benefits. However, when the person passes away, Medicaid, Medi-Cal can come in and recapture the amount of money they paid during the person's life. And there's no liability protection from creditors or for the bankruptcy court. So it does work. It's sometimes created by a court with the beneficiary's own money, but it is subject to chargeback from the public the governmental agency that's paying the public benefits. Now, if, let's say, spouses wanted to create a special needs trust for another spouse, let's say their mental capacity is diminishing quickly, spouses have to create a special needs trust for the other spouse within the context of a will, and not within the context of a normal, what we call a revocable trust or revocable living trust or family trust that's revocable. It must be specified in the will. And when a will is says there's going to be a trust created later, that's referred to as a testamentary trust. So by and large, the majority of the special needs trusts are created for individuals with some sort of disability. And the disability could be defined as they're not capable of taking care of their own needs for daily living. Maybe they can't dress, they can't walk, they can't talk, they can't manage funds, they don't have mental capacity to be able to think rationally and make decisions. So that would be a criteria usually for obtaining government benefits. So they're very valuable to have for individuals that say they're going to inherit a large amount of money, but they're on public benefits. And the objective is to keep the funds away from the direction and control of the person who has the incapacity. So they're very useful for people with disabilities, and they're quite popular and very useful. If you have other questions about special needs trust, you can call our office. We're at phone number 925-934-6320. And our email address is rexcrandell@astound.net. Thanks for listening.